Good morning, everyone. I'm speaking to you today from the lands of the Kulin Nation, and I acknowledge and pay my respects to their elders past and present, and all those Aboriginal and Torres Strait Islander people who are custodians of the land and waters we call Australia. I want to thank the CNTA and Julie Finlayson and Nick Peterson in particular for their invitation to speak and for their support as we've now navigated the changing course of COVID-19 and its impact on this conference, and as we've navigated the technological challenges of doing a keynote speech this way. I really regret not being there in person with you all, as I was very much looking forward to all the conversations to be had outside the official presentations, and also to learning a great deal through those presentations. So another time, I hope. The topic of my presentation today fits reasonably well into that part of the conference theme dealing with collaboration, because what I am inviting you to consider as potential and actual expert witnesses, and to raise with those who may instruct you in native title determination or compensation claims, is a creative approach and substantive collaboration on the use and presentation of anthropological expert evidence in the modern pressed litigation environment. As Nick said in his presentation, it may involve you moving out of your comfort zone. Now, I hasten to add the same proposition applies to native title lawyers, but that's not who I'm addressing today. What I say is derived only from experiences as a judge in the federal court's jurisdiction, and what I say is intended to apply to proceedings that arise in that jurisdiction. I do recognise that anthropologists perform many other important roles working with First Nations peoples, both within the native title sphere and outside it. Some of what I say may be applicable to other areas, but that is not my primary focus. I want to start with an observation. Despite the legal and social revolution, which was Mabo number 2, seems to me that First Nations peoples themselves tend to have been treated as the objects of the native title system rather than as equal participants in it. Sometimes more as bystanders, and sometimes as quite powerless bystanders at that. When we describe the history of native title claims and decisions, when we describe their legal and evidentiary framework, and the course of judicial and parliamentary decision-making, we are describing events and processes undertaken largely, if not exclusively, by non-Aboriginal people, and certainly controlled by non-Aboriginal people. That situation may be changing, albeit slowly. There are steps that the courts, judges, practitioners, experts, representative bodies and their staff, and government can take in the way they conduct native title proceedings and native title negotiations to move towards redressing and changing that dynamic. Today, my focus is on one aspect that may contribute to such a shift, namely the potential for changes in the preparation and use of anthropological opinions. Some possible changes, some of the ones I'm going to mention, may give First Nations peoples more prominence in the determination and compensation process. Some may empower them simply by speeding up the time it takes for them to secure a resolution to their applications. Of course, a determination of native title or a compensation payment is not the end of the journey for First Nations peoples, and hopefully it is indeed the beginning. But that is the part that the court is concerned with. I accept that what I say today might be somewhat provocative, and in a way I hope it is. None of what I say is directed at particular individuals, institutions, or agencies. My thoughts are offered with the premise that everyone here, and everyone who may come to know what I've said, works in good faith and with positive intentions to assist First Nations peoples as far as the law allows to regain and exercise custodianship over and responsibility for their country, which European settlement has disrupted. I want to spend a little time talking about the features of this court's, the Federal Court's native title jurisdiction, which are important to what I have to say. Firstly, it is still a new and developing area of law, just on 30 years old, in a common law system that puts it in its infancy. That said, a good deal of legal groundwork has now been laid. Not to say that some of it might not change, and maybe it should, but judges, practitioners and experts who are working on proceedings in 2021 have the benefit of the hard work of those who did many of the early cases and established some working principles and practices. Now, that feature has led to a less adversarial approach being taken by respondents, especially government respondents. The days of hundreds of objections, of interminable fights over admissibility, which only lawyers and judges are interested in, of taking legal points for the purposes of obstructing claims because the party objecting has an interest in obstructing claim, those days have largely gone. The change in attitude towards native title claims has been tremendous, and it is a sign of a less fearful, more mature and fairer approach to the recognition of the rights of First Nations peoples in their country. Native title is one of the few areas of the court's work which can, in principle and now in practice, be a constructive and positive undertaking, which need not be intensely adversarial. That is the tremendous advantage of the consent determination process and of the mediation and negotiation processes in our court. They are intended to be cooperative and to work towards a positive outcome for all parties. Rarely can that be said of contested litigation in this court. But, and it is an important but, what we deal with is still litigation conducted under the auspices of an adversarial system with all the rules that accompany that system. The role of experts in this system outside the native title jurisdiction is well defined. And as you all know, the legal view of an expert anthropologist's role does encounter some difficulties when it's measured against the role of experts in other jurisdictions. But that said, the objects of the Native Title Act and the powers given to judges and registrars under it, combined with the powers in the Federal Court Act, mean there is tremendous flexibility available to rethink how best to assist First Nations peoples and others affected by native title claims to achieve a resolution. Finally, and perhaps most crucially for my topic today, the native title jurisdiction is notorious for consuming huge amounts of public rather than private resources on the sides of claimants, government respondents and the court. It is also notorious for having cases which take much longer to resolve than cases in other areas of this court's jurisdiction. I encourage you to question the fiction that native title cases are so special and so complex that this inordinate length of time that they take to resolve is justifiable. I challenge you to think that it may not be justifiable. This court deals with highly complex litigation in many areas. Class actions are a good example. But the throughput is universally faster than in this jurisdiction. And as many of you know, there are native title claims in this court which were lodged in the 1990s. Not as many as there used to be, but still a measurable number. And plenty which were lodged in the 2000s. That's 20 years ago. It has been one of my personal missions since commencing work in this area to get old claims resolved. I'm like a stuck record about the tragedy of those elders whose knowledge is critical to a claim passing away before it is resolved. My topic today is very much driven by the unacceptable delays which have been a feature of this jurisdiction since its commencement. The gathering of anthropological expert evidence is a contributor to those delays. I feel we must recognise that. It is by no means the only one, but it is a contributor. I want to now talk a little bit about why I think a re-evaluation of the approach is necessary, and I think there are three driving forces. Firstly, the nature of the work which is ahead for this court, including compensation claims, where we really do have a chance to do things differently in a new aspect of the court's work. Secondly, the costs of native title proceedings and the ever-present problem of funding difficulties. And third, as I have said, the tragic impacts of delay on claim group members, on their communities and on First Nations peoples in a wider sense, and the impediment this provides to greater self-determination and better overall life outcomes for those communities. So I want to just touch briefly on some of the challenges for judges with the current approach to expert reports. And I know that Justice Rangia addressed you all last year about this, and I agree with what he said. And I just want to remind you of a couple of things that he said and then add some thoughts of my own. Justice Rangia noted, and I'm obviously summarising, that judges sometimes find anthropological reports challenging to navigate, that they find the conflicts between anthropologists in a given case difficult to unpick, and they experience frustration with court timetables not being met. Sometimes identifying the real issues in dispute from the reports is challenging. Now, the last observation, it can be equally true of the presentations of lawyers, I might add. My own thoughts on some of the challenges are these. I'm going to start with one that I know is a little bit controversial. A feature of anthropological reports which is difficult for judges and for legal representatives in a contested hearing is something that was identified by Justice Sackville in Django at paragraph 15. I know that's a controversial decision to mention, but at least this observation, in my opinion, had some force. And it's this, it's about the duplication of factual material sourced from claimants that you get in expert reports and then that you get again in witness statements. Now, I know that there have been some commentary on this, and I've read what Dr. Kingsley Palmer's said about this, and I understand a different perspective might be held. But I can tell you from my own experience of being the person who has to unpick all this and who ultimately has to decide what is the most reliable evidence that's being given by claimants, that this practice of seeing what they say in two places as part of fieldwork and reports and then as part of witness statements is a really significant problem in working out what is the most reliable evidence. And it also leads to tremendous difficulties for legal practitioners and for First Nations witnesses when they are questioned in terms of putting previous statements to them. So that's a real challenge, and I think some of that comes from the lengths that experts are asked to go to in the way they prepare their reports. It is true that one of the key areas of value to judges from anthropological reports is an analysis of the at-sovereignty position, being an issue about which direct evidence from claimants is unlikely to be comprehensive. However, the working out of legal principles in detail, the examples of the application of those principles to a now wide and plentiful body of decisions and claims should mean that there should be increasing common ground on many at-sovereignty factual issues, and that the areas of dispute on which opinion evidence is truly required should be more focused and should be smaller in number. We do not see that in the instructions given to anthropologists, and we do not see it in the reports that are the products of those instructions. We seldom see any building off findings in other cases, although that approach, at least to my mind, should be readily available. Now, that requires better and earlier collaboration between lawyers and their experts, and it requires a change in approach from lawyers. Another feature which is a challenge is that whether in the form of a report or as part of an iterative process before and in the preparation of an application to this court, there can be a tendency for expert anthropological opinion to drive the framing of a claim. There are a number of things that might be said about this tendency, whether conscious or unconscious, but there are two that I want to highlight. First, that tendency diminishes the position of the accounts of First Nations peoples themselves, and it contributes to an impression that they are being led through a process which is about them, but is not coming from them. It leads to a sense, which I hear and see a lot, that unless you have an anthropologist, a claim group cannot succeed. I do not agree, but that impression is what spirals into the funding dramas that take years to resolve and often provides an impediment to the resolution of claims. We don't have an anthropologist, therefore we can't do anything. Second, looking too readily to an anthropologist to frame a case tends to relieve legal representatives of the task of applying the instructions and the evidence they gather from their First Nations clients to the law as it presently exists. That is their function. That's a lawyer's function. And yet lawyers can tend to rely on anthropologists to do that work for them. That is a feature which leads to obvious problems about independence, about which much has been written. And it's not, I hasten to add, a problem of the anthropologist making, although that you can be the ones that bear the consequences in contested litigation. So what might be done differently? Now, it's important to reflect on what I've already said before reaching what I say about the answers to that question. But the purpose of thinking differently about expert anthropologists in both determination and compensation applications is to address the features I've spoken of: delays, cost, lack of clarity of claimant accounts, passing of responsibility away from lawyers, failure to make appropriate use of existing findings and accepted positions in preparing new claims, and the lack of centrality given to claimants in the judicial process. So I want to divide what I say about what might be done differently into two parts. The first part dealing with negotiated outcomes through consent determinations, and the second part dealing with contested situations. But the basic theme is the same in each part. Those involved in determination applications should now have a reasonable idea of when a native title application is likely to follow a successful consent determination path and when it might not. It is more difficult at the moment to determine that in relation to compensation applications because we're really just embarking on working out the legal principles. But we've had 30 years of experience with native title determination applications. And if I'm going to take the Western Australian Government's guidelines for consent determination as an example. Now, they expressly state at paragraph 3.5 that a single connection book or the like need not be presented. They state that connection material should be, and I quote, practical, straightforward, and clear. They state that connection material should be accompanied by a brief legal submission, setting out how that material satisfies the relevant criteria. That is, it's not the anthropological opinion that needs to join all the dots, and indeed it shouldn't be. That's the lawyer's job in the legal submission. The guidelines state at 3.7 that the most important information in support of claim native title rights and interests is primary evidence provided by Aboriginal people. The guidelines state, under the heading of essential requirements, precisely what factual matters have to be addressed. And most of those primary factual matters are matters for claimants. Some of them will no doubt benefit by being supported by an anthropological opinion to clarify or endorse the primary evidence. And as I've said, at sovereignty, factual issues may often be developed by anthropologists from secondary sources rather than from claimant accounts. But much of the at sovereignty position is now well established across most of Australia by decided cases and by negotiated outcomes. So my point is that these kinds of guidelines, promulgated expressly by government for the purpose of consent determinations, are clear and targeted, and they lend themselves to quite summary documents. In my experience over the last 6 years, government is generally ready to engage with claimants and their representatives to explain what aspects of the Section 223 definition they are satisfied with and where they need more detail. An iterative and consultative process is always going to be more efficient and cost effective. As experts, you can encourage this. Question if your brief seems to ask you to reinvent the wheel. Insist on more targeted instructions. Draw on your knowledge from other cases if the breadth of your task seems unnecessary. Ask whether discussions have been had to narrow the issues before approaching you. Propose early, informal expert conferences, drawing on other work that you may have done. In some cases, you may well have more experience than the lawyers instructing you. Use it to think about and suggest more efficient ways the claim could proceed. That is not framing the substance of the case. That is simply acting in an efficient and cost-effective manner, which the Federal Court Act requires of all parties and their representatives. Now, in contested litigation, the theme is really the same. It is almost never the case in contemporary contested native title litigation, whether it's intra-Indigenous disputes or disputes with non-Indigenous respondents, that all aspects of the Section 223 definition are in issue. I am putting tenure to one side. Again, the refinement and development of legal principle and its application means that parties can be more focused. The issues tend to be matters about boundaries, overlaps, correct apical ancestors, correct composition of groups, continuity. So there are no blank slates anymore. And preparation of claims and evidence should reflect this. Sometimes decided cases will drastically affect the likely resolution of claims. That should mean that more facts are able to be agreed between the parties, agreed early, and don't need to be the subject of any expert reports. Most claimant groups understand more about the native title process, for better or for worse. Most will have seen wins and losses by other groups in relation to other country, and many will have been through the same process for other parts of their country. So there is a significant and important burden on legal representatives and representative bodies to ensure their clients are informed, have realistic expectations, and understand the court's contemporary emphasis on negotiated outcomes. I am not convinced these matters are as prominent in practice as they should be. There is a significant burden on state governments not to take technical points and to focus on substance in a way likely to produce the most efficient result. Last year, a full court of this court emphasised that in a New South Wales decision called Widgeable. The citation is 2020 FCA FC 34. And in that, the court emphasised that the state has to act in good faith in negotiating native title outcomes, objecting only when there is a real and substantive matter which stands in the way of its agreement to native title being determined, and that all that is required for a consent determination is satisfaction by the state of, and I quote, a credible basis for the existence of native title rights. Now, all of these factors and principles should mean we can do anthropological expert evidence more efficiently and effectively with less expenditure of time and resources. In no particular order, some of my suggestions are these. First, lay evidence could come ahead of the preparation and filing of any expert evidence at all. This might mean not only preparing and filing the evidence, but the court actually taking the lay evidence first. Now, that doesn't mean anthropologists working with groups cannot assist lawyers in this process, although, as you're all aware, you have to be careful about that. Fundamentally, however, there is a logic to that, which I want to invite you to consider. So far as the law is concerned, opinions are based on primary facts, which are to be proved in the usual way, accepting that in a native title context, we in practice apply more flexibility about admissibility. But aside from historical and ethnographic sources, the primary facts are the accounts of the First Nations people themselves, living or recorded. So one option, which may help avoid the duplication that I referred to earlier, is to have the lay evidence prepared and heard ahead of any expert opinions. Seems to me that that process will not only focus the expert evidence, but it should clarify what aspects of the Section 223 definition are really an issue. The second suggestion I have is the use of summary expert reports, which are produced only to focus on matters actually in dispute. And I say summary because they may take as agreed or accepted a number of matters. What is the system of law and custom that's applicable? What's the at sovereignty situation in a region? And they may be able to cross-reference to other decisions, other findings, or other opinions, rather than repeating material that exists elsewhere. Third, I think there's a great potential for oral expert presentations at registrar-led conferences, after, of course, parties and their lawyers have provided input on what the topic should be. But such registrar-led conferences could involve an exchange of views by the experts and the production of only one written document which reflects those views, what is agreed and what is not, what is important and what is not. That is, the suggestion is no advanced written reports at all, simply that all the experts go along to this registrar-led conference and talk to each other, led by the registrar. That could produce a great saving in time and money, and potentially a useful discipline for all in focusing on what is really in dispute. I'm suggesting in that, just to be clear, that that's a way of using the expertise of anthropologists without requiring the very lengthy and expensive process of the production of a report first. Fourth, there's also a great potential for anthropologists to assist in registrar-led mediations, that is, in confidential discussions. Of course, that may affect whether the same expert could give expert evidence if there was a trial. I accept that. But the point I want to make here is that early anthropologist-assisted mediation may well resolve disputes, especially intra-Indigenous disputes. And so the theoretical issue of whether that person can or can't give expert evidence at the trial, we would hope, remains a theoretical issue, because the early intervention in a confidential setting of an anthropologist assisting a registrar in a mediation can resolve the issue. A fifth suggestion is, along the same kinds of lines, is very early expert conferences, perhaps in a mediation context, perhaps in an open context. Again, may not depend upon each expert having prepared a written report. As experts, you can all be assumed to be able to do your research and express an opinion with whatever notes or assistance you need early in a negotiation context. You know your stuff, you know your material, you know the people you're working with, you know the issues. Many of you will have worked in the regions concerned before. You may have worked with the people concerned. You may have familiarity with the system of law and custom that's involved. As experts, you don't need a written report in order to articulate what your views are. Free and frank exchange of views between experts at a very early stage, again, may narrow issues. They may make parties more realistic. That is a really important issue. It's a very advantageous attribute of working with anthropologists in these cases, that you can introduce some realism to the position of the parties. But at the moment, that tends to happen right at the end of the process. And what I'm suggesting is cost-effective, non-writing based interventions early in the process may be what can make parties much more realistic and can help work through potential resolutions. Finally, another suggestion is the appointment of a single agreed anthropologist as a court expert. Now, again, recalling that we're not really starting with a blank slate anymore, and a lot of work has often been done that's relevant to the particular land and waters with which a proceeding might be concerned. And sometimes I find it's depressing and frustrating to see the duplication of expert work in some cases. Numerous reports by various people over numbers of years, sometimes over decades, and the claim is still not resolved. Now, court experts are used very effectively in other areas of this court's jurisdiction. The parties generally fund a single expert. Of course, that's uncomfortable. Of course, that's not the normal adversarial approach. But that's really the message I'm trying to get across, that these sorts of changes and modifications to the way we look at how to produce an opinion that will assist the judge are very important. And a single court-appointed expert has the capacity to address and solve some of the challenges, for example, that Justice Rangia spoke to you about last year. So I'm not suggesting by any means that one size fits all and that all or any of these suggestions will be always appropriate in a case. But I do tend to think that one or more of them will be appropriate in most cases. And of course, I'm not suggesting that anthropologists can implement these changes alone. It must be the legal representatives and the representative bodies which lead the change. However, I'm encouraging you all to participate in bringing about that kind of change, in looking at ways to reduce the detail or content that needs to be produced, or to think of creative and more cost-effective ways to present your opinions. I accept that what judges or courts and sometimes lawyers insist upon or ask for may feel like an unreasonable or inappropriate compromise of professional methods in anthropological research. I accept that some of what I've said today may make you feel like that. But I say respectfully that this is a discomfort which I'd encourage you to overcome if you choose to participate as experts in contemporary native title litigation. I invite you to consider whether you can be prepared to accommodate the demands of adversarial litigation and legal method in what is now a pressed, modern litigation environment. We don't operate with any sense of leisure anymore, if we ever did. People's rights are at stake. Every month we delay is another month that First Nations people are not in control of their land and waters. Another month where their aspirations and expectations are not addressed as either realistic or unrealistic. In native title, of course, unlike other jurisdictions in this court, we don't speak in months, we speak in years and sometimes in decades. That is unacceptable and it has to change. With the compensation jurisdiction about to take off, I'm inviting you as key participants in this process to think about how we can do things more efficiently and more cost effectively this time round. Now, a response that is often offered when these sorts of comments are made is funding difficulties. I don't consider that is a sufficient answer. Yes, the representative bodies which fund this work sometimes do need to be reminded about their responsibilities, especially in relation to existing proceedings and the capacity of funding to frustrate the administration of justice. But there is a real role for an approach by both lawyers and, I venture to say, experts that thinks about cutting one's cloth to what is available. We may well find that more cost-effective approaches encourage the funders to be more forthcoming more quickly with modest amounts of money. If there isn't $100,000 for a full report, then all those working for First Nations people might need to find a different way to get outcomes with the funds that do exist. The answer is not to say, oh, well, we can't progress that application. That is the attitude that has to change. That is where we have to get creative about thinking, well, we have a small dollar amount. What can we do? These notions of cost, delay, efficiency, effectiveness, they are central to the functioning of a modern court. They have been neglected and downgraded in native title work, and that has to stop. We have to get better at being more efficient and more targeted. As I have tried to emphasise in this presentation, lawyers and representative bodies must lead this challenge, but I do think that anthropologists have a critical role to play, especially at trial level, which is what I am discussing. Judicial power is exercised in the real world in relation to problems of individuals and groups to solve disputes, to clarify what the law is, and to enable people to move on with some certainty and some finality, for better or for worse, but to get them an outcome. That is our collective function, no more sophisticated than that. We are not writing for posterity. We are not debating intellectual points. We are playing our role in resolving disputes for people whose lives are affected by the existence of that dispute. We need to encourage realism, pragmatism, and outcomes. And outcomes are something that First Nations peoples have not had enough of, in my opinion, and that is what has got to change. Thank you very much.